has suffered another major blow in his legal battle over the loss of his UK police protection after his bid to bring an appeal against a High Court ruling was refused today. The Duke of Sussex took legal action over the February 2020 decision by the Executive Committee for the Protection of Royalty and Public Figures, REVEC, which royalty would no longer be given the same degree of publicly funded protection when in the country. REVEC's decision came as a result of a change in the Duke's status after he stopped being a full-time working member of the royal family, a judge was told. In February, retired High Court Judge Sir Peter Lane rejected the Duke's case that he was singled out and treated less favourably by the decision and concluded REVEC's approach was not irrational nor procedurally unfair. After the ruling, a legal spokesperson for Harry said in a statement that the Duke hopes to obtain justice from the Court of Appeal. Today, a judicial spokesperson said Harry has now lost his initial bid to appeal against the decision. However, the Duke is still able to ask the Court of Appeal directly for the green light to challenge Sir Peter's ruling. In the order today, Sir Peter also said that Harry should pay 90% of the Home Office's legal costs, but said the government department had committed breaches during the legal battle which were sanctionable. The judge rejected an argument from Harry's lawyers that costs should be reduced by at least 50%. Sir Peter said, "There is no merit in this partial success submission. The fact that the court did not accept each and every submission of the defendant as to the path to take towards dismissal of the claim does not alter the fact that the claimant comprehensively lost." He continued, "They have resulted in the case being largely contested by reference to new grounds, which have not been subjected to the normal permission process. The breaches resulted from misapprehensions on the part of the defendant as to the duty of disclosure, which this decision has had to address at some length. It is therefore right that there should be a modest but still significant reduction in the award of costs to the defendant." Harry's lawyers had previously told the court that he was singled out and treated less favorably in the decision to change the level of his taxpayer-funded personal security. They said a failure to carry out a risk analysis and fully consider the impact of a successful attack on him meant the approach to his protection was unlawful and unfair. The court was told that Harry believes his children, Prince Archie and Princess Lilibet, cannot feel at home in the UK if it is not possible to keep them safe there. At a previous hearing the case in a written statement, Harry said, "It was with great sadness for both of us that my wife and I felt forced to step back from this role and leave the country in 2020. The UK is my home. The UK is central to the heritage of my children and a place I want them to feel at home, as much as where they live at the moment in the United States. That cannot happen if it's not possible to keep them safe when they are on UK soil. I cannot put my wife in danger like that and, given my experiences in life, I am reluctant to unnecessarily put myself in harm's way too." The government said Harry's claim should be dismissed, arguing that REVEC, which falls under the Home Office's remit, was entitled to conclude the Duke's protection should be bespoke and considered on a case-by-case basis. Home Office lawyers said the Duke was no longer a member of the group of people whose security position was under regular review by REVEC, but he was brought back within the cohort in the appropriate circumstances. After losing the challenge, a spokesperson for Harry said at the time, "The Duke is not asking for preferential treatment, but for a fair and lawful application of REVEC's own rules, ensuring that he receives the same consideration as others in accordance with REVEC's own written policy." In February 2020, REVEC failed to apply its written policy to the Duke of Sussex and excluded him from a particular risk analysis. The Duke's case is that the so-called bespoke process that applies to him is no substitute for that risk analysis. The Duke of Sussex hopes he will obtain justice from the Court of Appeal, and makes no further comment while the case is ongoing.